Hi there. Thanks for tuning in to the Freedom Update. Today I want to talk to you about a recent decision from the Supreme Court in a case that the Canadian Constitution Foundation was involved in as an intervener. The case is all about Doug Ford's decision in 2018 to shrink the size of Toronto City Council and whether this move was constitutional. Turns out it is. And we had argued that it was at the Supreme Court, so we were really pleased to see the court siding with us. I'm going to tell you a little bit about some of the arguments that we made, what the lower courts held, and why ultimately the Supreme Court sided with us. But I'm also going to tell you why this case is really important, yes, even if you don't live in Toronto. If you're new here, welcome. My name is Christine Van Gyn, and I'm the litigation director for the Canadian Constitution Foundation, a legal charity that fights for fundamental freedoms in Canada. I upload regular videos about ongoing cases that we have, as well as other interesting constitutional developments in Canada. So if that sounds like something you might be interested in, please hit like and subscribe below. It really helps my videos out a lot. And as always, please remember that everything contained in this video is for your information purposes only. It is not legal advice. If you have your own legal questions, please consult your own lawyer who can give you advice for your particular circumstances. So it has been crazy busy here at the Canadian Constitution Foundation. We're working on our challenge to vaccine passports in British Columbia. I'm trying to line up a major case in Ontario related to child protection laws. And we have 2 upcoming Supreme Court interventions. I also film 3 episodes of my TV show, Canadian Justice, every single week. And I have 3 kids and a dog. So my life is completely crazy. So I'm sorry if the videos are not as often or as frequent as you or I would like them, but thanks for sticking it out and subscribing because it really helps me out. And I will put a lot of work into these videos. So please leave me your feedback. I'd love to know what you guys think of the videos that I'm making. So I've just been really run down, and this decision from the Supreme Court was the good news that I needed. I'm really happy with it, and I'm really happy to see that the court did agree with some of the arguments that we made as an intervener at the Supreme Court. So let me tell you a little bit about the background of the case. In 2018, Doug Ford announced legislation that would shrink the size of Toronto City Council from 47 wards down to 25. Now, Ford said that he wanted to do this to improve voter parity because it would align the municipal wards with federal and provincial ridings to eliminate some confusion. And he also said that this would result in taxpayer savings. It would improve efficiency and reduce costs. Now, the move was really controversial because Doug Ford did this when the municipal election was already underway. So a lot of candidates needed to scramble to adjust their campaigns to the new 25 ward structure. And also the nomination period was closed. So candidates who might have wanted to join if it was a 25 ward structure, they were out. I mean, we all know that Doug Ford has his own relationship with Toronto City Council. It isn't an especially good one. So, I mean, you would be forgiven if you thought maybe there was some vindictiveness here as well. But it turns out that this move by the Premier was within his authority. The Supreme Court has upheld his decision to do it as constitutional. He was allowed to shrink the size of council this way. But when Doug Ford made this move, it was pretty quickly challenged in court. Some municipal candidates and the City of Toronto took the Premier to Ontario Superior Court and said that this was an unconstitutional move. The decision went before Justice Bellababa, and before him, the city made 2 main arguments. First, at the lower court, the city argued that Ford's move to reduce the number of wards violated the written right to freedom of expression, which is guaranteed by the Charter. And second, they argued that the reduced ward structure violated unwritten constitutional principles, in particular, the principle of democracy. So there were basically 2 arguments, one based on the written constitution and one based on the unwritten part of the constitution. Now, the province responded and justified the move to reduce the size of city council for 2 reasons. The first was the policy rationale. They wanted a more efficient city council by reducing ward numbers. They said it would increase voter parity and save taxpayer money. And then they had legal arguments where they said essentially that municipalities are creatures of statute and that their structure can be amended by statute. It's that legislation that regulates the structure of city council, not the right to freedom of expression. And while the charter does guarantee the right to freedom of expression, it does not guarantee that that expression will be effective expression. And the province also argued that Section 3 of the Charter, which guarantees democratic rights like the right to vote and to have effective representation, they argued that that only applies to federal and provincial elections. It doesn't apply to municipal elections. Now, it's true, when the Charter was negotiated, the municipalities were expressly left out of that Section 3 right. And the city argued it would be inappropriate for the court to grant charter protections that were expressly rejected when the charter was being negotiated. So that's what both sides argued. And what the lower court, Justice Balababa, ultimately decided was very surprising to a lot of people, myself included. I was involved with this challenge at the lower court level when I was with a different organization called the Canadian Taxpayers Federation. Now, the lower court, Justice Balababa, sided with the city and held that Ford's move to reduce the size of city council was unconstitutional because it violated the right to freedom of expression, as the city had argued. So this decision by Justice Balababa raised a lot of eyebrows in the legal community. What he held was that freedom of expression protects municipal elections, and this is despite the fact that Section 3, which explicitly protects elections, excludes municipal elections. And Justice Balababa seemed to hold that the right to freedom of expression actually protected a very specific ward structure, and that the transition from 47 to 25 wards was unconstitutional. And in fact, he got into a really granular analysis of what ward structures should look like in order to comply with the Constitution. Now, we all know we have a general guarantee of freedom of expression, but the notion that freedom of expression could extend to a specific configuration of wards struck many people as bizarre and wrong. It also struck many observers, including us at the CCF, as sort of twisting and warping our constitutional rights in order to achieve a very specific outcome, in this case, the specific preferred ward structure. So this was what the decision was, but the whole legal challenge was a very live issue because the clock was ticking down to the municipal election. So the Balababa decision, the lower court decision, was immediately appealed, and the Court of Appeal issued a stay that allowed the election to proceed, and it allowed it to proceed with the new 25-ward structure. Now, after the election took place, the Court of Appeal reversed the decision from Balababa, and ultimately the case went to the Supreme Court. Both the majorities at the Court of Appeal and the Supreme Court ruled that Ontario's legislation reducing the size of City Council imposed no limit on freedom of expression. This is contrary to what was found at the lower court. Both the Supreme Court and the Court of Appeal found that things really came down to the timing of the election. At the Supreme Court, the majority found that there was enough time after the legislation was announced and the new structure of council created for candidates to reorient their message and convey it to voters. They had 69 days from the announcement until the election, and 69 days is actually longer than a lot of provincial and even federal election periods. The court found that this amount of time, 69 days, did not radically frustrate voters or candidates' freedom of expression, and it didn't effectively preclude their ability to have meaningful expression. The court did give the example if there had been something like a 2-day election period between this change and when the election took place. They said that that could be enough to frustrate and preclude meaningful expression, but that wasn't the case here. They had 69 days. The court did find that by changing the structure, the premier may have been making some of the candidates' expression less effective, but that's not one of the guarantees under the Charter. You have a right to freedom of expression, but not to effective expression. And finally, the court confirmed that Section 3 voting rights do not apply to municipal elections, and they can't be squeezed into Section 2B freedom of expression the way they had been at the lower court. So that was the outcome of this case, but what really matters about it is something I mentioned at the beginning, the role of unwritten constitutional principles. Now, the court held that unwritten constitutional principles cannot be used to invalidate legislation, and this is a big deal. So let me get back to basics. When we talk about the Constitution in Canada, we're usually talking about written documents, the Constitution Act and the Charter. And this is mostly accurate. These are written documents that make up our Constitution. But the Supreme Court has also recognized that part of Canada's Constitution is unwritten. It has said that there are 4 unwritten principles of Canada's Constitution that can come into play: democracy, the rule of law, constitutionalism, and protection for minorities. So we know that Canada's Constitution, it's kind of a mix of these things and our written documents. What's been unclear, though, and subject to a lot of debate in the legal community, is whether a court can rely on these 4 unwritten constitutional principles to strike down legislation. We know that courts can rely on the text of the Constitution to strike down legislation. We've seen that in all sorts of cases. We work on those sorts of cases at the Canadian Constitution Foundation. But we didn't really know if these 4 principles can be used to strike down legislation or whether they can just be used to fill in gaps where constitutional written documents are unclear. For a non-lawyer, I understand that this may seem a little bit theoretical. And to be frank, that's part of the issue. These principles are theoretical. They're unwritten, they're general and abstract, and they're broad concepts. And their importance in a particular case can only be ascertained or divined by judges who are fairly cloistered, unelected, and not democratically accountable. These principles are not available for ordinary citizens to read or be informed by. Relying on unwritten constitutional principles has the potential to create purely judge-made law that's not amendable by legislators. So aggrandizing the role of unwritten constitutional principles is a very shaky proposition. And it's one of the things that some people in this case were arguing in favor of, including the City of Toronto. They were arguing that these unwritten constitutional principles could be relied on to invalidate the legislation that Doug Ford had brought in. Now, ultimately, in my opinion, this was the most important part of the case. The CCF made arguments at the Supreme Court about this exact issue, and we argued that unwritten constitutional principles cannot be used to invalidate legislation. We argued that we have a written constitution, and we made certain choices as a country about what to protect and what not to protect. And the court can't rely on these unwritten principles that aren't actually even provisions of the Constitution to find laws are invalid or to expand the scope of existing rights beyond what's actually prescribed in the written charter. If there are gaps in what the written text of the Constitution says, unwritten principles can be used to fill those gaps. But when the text is clear, as it was in this case, there is no room for unwritten principles. Ultimately, we were really happy with the majority decision. The majority said that unwritten principles can't be used as the basis for invalidating legislation. And the majority said that charter interpretation and interpreting laws has to begin and be rooted in text. Unwritten principles form part of the law in the sense that they are the context for interpreting laws, but they can't be used as a freestanding basis for invalidating written laws. But this was a really close case. It was a 5-4 decision with a forceful dissent. In short, the dissent would have allowed the unwritten constitutional principle of democracy to overturn the legislation. This is a really difficult proposition, in my view, to support, since these principles are really abstract and can mean many different things, and relying on them would create a serious rule of law and predictability issue. But the fact that this case was so close, 5-4, suggests that at the end of the day, the role of unwritten constitutional principles really may not be settled. The debate will almost certainly continue, and judges retire. There's a mandatory retirement age, and a one-judge change could result in a very different outcome in a future case. But at least for now, there's been some guidance on when and how unwritten principles can be used. The idea is to start with text and then use unwritten principles to fill any gaps. Now, I'm sure that we will continue to see unwritten principles make their way into lawyers' arguments when they appear before courts, but I think that it's important that we now have this majority decision to guide us. And I'm really happy with the result that unwritten constitutional principles can't be used to invalidate legislation. But I have to say, I am very troubled by the 5-4 split, and likely this issue isn't settled for good. Okay, that's all for this update. Thanks for tuning in. I really hope you learned something today, and let's keep fighting for freedom in Canada.